Okay, it's 11 o'clock. We're going to go ahead and get started. Good morning, everyone, and thank you for joining us today. My name is Ann Meredith, and I'm excited to be your moderator for this webinar hosted by UPS Supply Chain Solutions. We've got an exciting session lined up for you today, and whether you're returning after our April session or joining us for the first time, we are thrilled to have you here with us today. Today's session is a continuation of the important conversations we began in April, and we're diving even deeper into the evolving landscape of global trade and compliance. We'll explore newly issued executive orders, policy shifts under the current administration, and sector-specific updates that are shaping global supply chains. Our goal is to equip you with the knowledge and tools you need to stay informed in this rapidly changing environment. But before we begin, I have a couple of admin updates to share. This webinar is being recorded, and both the recording and the presentation will be made available to everyone who registered. We also encourage participation and would like to ensure we answer your questions, so please make use of the Q&A function at the bottom of your screen. I'm excited that we have a group of our subject matter experts from our compliance team on to help answer your questions as we go through the webinar. So please feel free to put your questions there and we'll answer them throughout the webinar. And we ask that you don't put the questions in the chat because a lot of times they will get lost and we won't see them and get to them. So please use the Q&A. Also, after the webinar has finished, please watch for a post-webinar survey to appear. If you could fill that in, we always appreciate any and all feedback you may have. And now for legal purposes, I will read the following statement verbatim. At the date of this publication, policies are evolving. This presentation is for informational purposes only. It does not constitute legal advice. Please consult with your own legal counsel for such advice. Do not rely on this information without performing your own research. All right, with that, let's start by introducing our distinguished speakers who bring a wealth of experience and insights to today's discussion. As mentioned, my name is Ann Meredith, and I'm Senior Marketing Analyst for UPS Supply Chain Solutions. We have Mark Hartledge, U.S. Small Pack Compliance Manager, Catherine Meller, Vice President Global Public Affairs, and Jessica Rosen, Senior Director of UPS Trade Advisory Services. Thank you all for being here with us today. We appreciate it. And before we dive into today's discussion, let's take a quick look at the agenda. We'll begin by exploring trade and tariff update, what's changed since April, political climate and policy outlook, and strategic response, moving beyond the 10 steps that we discussed in our first tariff webinar back in April. So with that, I'm going to turn it over to Mark to get us started on our content.
Thanks, Ann, and good morning, everybody. As Ann stated, my name is Mark Hartledge, and I'm a U.S. Brokerage Compliance Manager on our Small Pack Division. Today, I'm going to take some time and discuss the roller coaster ride that we've seen since really back to February 4th. We understand the impact all these regulatory changes have had to our business and especially to our customers. If you import anything to the United States, you most likely have been impacted by these changes, and these changes can be very difficult to understand. So in the next several slides, I will review a timeline of some regulatory updates that have had the largest impact, and then provide some insight on several of these trade remedies on how to understand them better. Before I jump into our latest updates, I want to look back and talk about when this all really started. As I stated, February 4th was the beginning of our roller coaster ride. It all started with the International Emergency Economic Act, also known as IEEPA. These IEEPA tariffs were directed at Canada, Mexico, China, and Hong Kong on that date. We have seen many shifts in the IEEPA 1 trade remedies, and I've also seen the addition of IEEPA 2 reciprocal tariffs. The Section 232 tariffs have also seen many additions since the trade remedy was modernized back in 2018. So now I want to review an abbreviated timeline of several key events. As we jump forward to April 3rd, this is when we first saw the Section 232 tariffs applied to certain passenger vehicles and light trucks at a 25% rate. We will provide more details on these Section 232 auto tariffs in a later slide. Next, on April 5th, the IEEPA 2 reciprocal tariffs were initiated at a 10% baseline for all countries until April 9th, where 60 countries would then receive a specific tariff rate according to the trade deficits with the United States. Those specific rates were only implemented for 1 day. And then on April 10th, the U.S. made the decision to pause those specific country rates back to 10% for 90 days until July 9th, which now we understand has been updated to August 1st. This pause was allowed to for further trade negotiations between the U.S. and other countries. The exception to this was for China, Hong Kong, and Macau, as IEEPA 2 reciprocal tariffs at that time were increased to 125%, which were later adjusted down. Next came April 29th, where U.S. Customs provided guidance on how to stack and manage all the IEEPA 1, IEEPA 2, and the China 301, along with the Section 232 tariffs, as it was becoming more challenging to handle all the new tariff numbers at once. We will also provide more details regarding the stacking process later in the presentation. May 2nd brought another major change. The de minimis duty-free exclusion for low-value shipments was removed for all products of China, Hong Kong, and Macau. This is another topic we will discuss in another slide as it's becoming a higher priority for the U.S. administration and specifically for U.S. Customs. The very next day, on May 3rd, Section 232 tariffs were placed on certain auto parts at a 25% rate, with the exception of parts that qualified for USMCA for Canada and Mexico. Those auto parts were also associated to the automobiles that received the 25% back on April 3rd. All right. Then we had a slight reprieve until May 14th. This brought the new announcement that U.S. and China were in trade negotiations, and the IEEPA 2 tariffs were moved back down to 10% from the 125% that were originally proposed. This announcement was also a 90-day pause. The next significant date came on May 28th, where we saw the Court of International Trade and the U.S. Court or District Court strike down the use of IEEPA, stating that IEEPA tariffs were unlawful. The next day, a stay was issued for the government to file an appeal for these rulings. Catherine will provide the latest update during her presentation later. On June 4th, then brings a higher tariffs of 50% increase on steel and aluminum products and their derivatives for all countries with the exception of UK products. The US and UK agreed on a trade agreement that would keep these tariffs at the original 25% that was established back on March 12th. That brings us to June 28th, where the U.S. administration provided clarity for aluminum content for these aluminum derivatives. Now you must report the country of cast and smelt for aluminum content of these derivatives, and if you're unable to determine the country of cast or smelt, you may be subject to up to 200% tariff and duty rate. This can be very impactful, so we'll review this in more detail later in the presentation. So as you can see, there's been a great deal of activity and changes since early April, and I'm sure there is much more to come, for sure. Before I move on to the next slide, I would like to explain how we as brokers and anyone that imports to the United States are notified of these changes and how these changes will be implemented. Throughout the presentation, you may see a source or a reference to a CSMS number. This may be something you're already familiar with, but for those that are not, CSMS stands for Cargo Systems Messaging Service. U.S. Customs utilizes the CSMS to notify and provide direction of how these changes will happen. Normally, the CSMS is the last form of communication Customs sends before implementing any change or update. These notifications also include data requirements along with the timeline of the changes. If you'd like to review these CSMS messages, we've added the CSMS link to the reference page at the end of this presentation that you'll have access to. It's a great source to find out just what's happening with U.S. Customs and these regulatory changes. So next I want to dig into some of the commodities that I just spoke about, along with a few other initiatives we've seen Customs take on here recently. The first one Or I'm sorry, in the next two slides, I would like to touch on the Section 232s for automobiles and auto parts, and then we'll touch on Section 232 tariffs for steel and aluminum and their derivatives. We've seen these trade remedies impact a large portion of our customers, so hopefully you will have a better understanding of how these tariffs are determined and applied after I provide some details. The first is the Section 232 tariffs for automobiles and, more importantly, the auto parts. The Section 232 tariffs for auto and auto parts are driven by certain tariff numbers that U.S. Customs has deemed to have an impact on the industry's trade deficit. Starting on April 3rd, like I talked about in the timeline, a 25% tariff for autos was imposed on passenger vehicles. These were applied to all countries that are importing the United States. 1 month later, Section 232 tariffs of 25% were implemented on auto parts of those same passenger vehicles. Over 130 auto part tariff numbers are now subject to the 232 tariff of 25%. A positive sign that trade negotiations are working between countries is the economic prosperity deal between the U.S. and the U.K. This was put in place on June 30th, which gave relief to automobiles and auto parts in the way that they reduced the tariffs down to 10%. Okay. This also gave relief to certain civil aircraft parts of UK origin, and those will actually be awarded a duty-free tariff rate. All right. Moving to the next commodity is the 232 tariff remedy for steel, aluminum, and the derivatives of the steel and aluminum. This trade remedy has become very challenging as there are several different requirements for both products and the derivatives. When we speak of derivatives, in general, U.S. Customs describes a derivative as a product that contains either steel or aluminum, but is classified outside of the steel or aluminum chapters 73 and 76 respectively. So as an example, if you have an item that contains aluminum and the tariff number for that item falls in chapter 84 and is listed on the CBP tariff list for aluminum, then it's considered an aluminum derivative. Once the item is identified as an aluminum derivative, you must know the country of origin of the derivative and the country cast and smelt of the aluminum content contained in that derivative. Not the easiest thing to understand. For aluminum derivatives, if you do not know the country of cast or smelt, you will be subject to a 200% tariff of the aluminum content of that item. This means you need to know the value breakdown of the non-aluminum portion and the value breakdown of the aluminum portion of that derivative. We understand this can be very difficult to obtain, but it is a requirement of U.S. Customs. If you do not know the country of cast or smelt, and you also do not know the value breakdown of the aluminum versus the non-aluminum, then you may be assessed 200% at the full value of your item. So documentation and a strong understanding of your products and how they are produced has become even more important when dealing with steel and aluminum products. You should work with your suppliers, vendors, and/or manufacturers to assure these details are provided. Without this information, it can become very costly when importing these steel and aluminum items. I've listed the CSMS message that contains the U.S. Customs formal communication, and that CSMS message has links to all the tariff numbers that are associated to the Section 232 requirements. Now, moving forward, now that we've touched on the complex Section 232 tariffs, I'd like to talk about the way which trade remedies are applied to each product. We now have many different trade remedies, and many of them overlap each other, or many products are subject to multiple trade remedies. Because of this, U.S. Customs issued a CSMS informing the importing community that they will deploy enhancements in their system to allow up to 32 tariff numbers. Yes, I said 32 tariff numbers on a single commodity line. This was previously moved from the 8 limit that was in customs system before this. I've been in the business for over 30 years, and I cannot imagine having to place 32 tariff numbers on one commodity. But this is the reality of where we're at today. On this slide, we've provided the details from U.S. Customs on how we stack tariffs. As I stated earlier, the Section 232 auto parts trade remedies takes precedence. If you have an item that is subject to 232 auto or auto parts tariffs, then that item is not subject to Section 232 aluminum steel or the IEEPA 2 reciprocal tariffs. However, if the item is a product of China and Hong Kong, then you are still subject to the IEEPA 1 tariffs for that item. As we move down the line, if no Section 232 auto parts or automobile tariffs apply and is subject to 232 aluminum steel tariffs, then the item is not subject to IEEPA 1 Canada-Mexico tariffs. However, the IEEPA China and Hong Kong tariffs are still applicable. So it can be very confusing. Lastly, I would say if your item is subject to China 301 tariffs that were implemented back in 2018, those China 301 tariffs will still apply and are not impacted by recent 232 or IEEPA tariffs. I've also provided the CSMS number for this at the bottom of the slide if you'd like to look at it and dig into it more. As you can see, this stacking process can be very complex. My next topic is something that's not new, but is a topic that has gained a great deal of relevance over the last 5 to 6 months. I'm speaking of the country of origin of your products. The regulations have always required proper country of origin. However, as we move through all these trade remedies and regulatory changes, the country of origin can have a large impact on the way your shipment is entered in the United States. I've already spoken about the 232 tariffs and how not only the country of origin can impact your shipment, but now you must know the country of melt and pour for steel derivatives, and you must have the country of cast and smelt for aluminum derivatives. As I stated earlier, if you cannot provide the country of cast and smelt for the aluminum, then you may face up to 200% tariff for that item. We understand the rules of origin are complex, so the closer you work with your shippers, vendors, and suppliers, the less impact you will see on your U.S. imports. We also advise that if you are dealing with products that are subject to 232 and possible other trade remedies, you look into consulting a trade advisor as they may be able to help you navigate these difficult and sometimes confusing requirements. There's also been communication posted that many countries will move back to the country-specific tariff rates, so the country of origin should remain a priority for importers as it may drive future tariff rates. Okay, on the next slide, over the last year, the importing community has seen a shift in CBP enforcement priorities. We are seeing CBP staffing grow on the enforcement side, as opposed to more automated initiatives on the facilitation side. On this slide, we've listed just a few of the priorities CBP is focusing on. The first is the national and economic security of the United States. I think it's safe to say that we've all seen the measures the current administration is taking to secure our borders. I would also say that if you're on this webinar, you most likely have been impacted by the trade and economic measures the government is taking to protect the U.S. economy. Another initiative that we've seen CBP make a priority is the use of forced labor. Although it was established back in 2022, U.S. Customs has greatly increased the Uyghur Forced Labor Prevention Act enforcement efforts. This is also better known as UFLPA. This was established to combat human rights abuse while at the same time enforcing ethical supply chains. Uyghur is a region in China in which U.S. government has found that has a large workforce that revolves around forced labor and human rights abuse. We are seeing an increase in inspects, detainments, seizures, and denied entries from U.S. Customs at all ports due to products found in this region. I know I spoke earlier about a close working relationship with your shippers, vendors, and suppliers, and this is another reason to build that strong relationship. This will allow you to understand when you may be at risk when it comes to forced labor. The last priority I'd like to touch on is the enforcement of intellectual protection rights, or IPR. The number of shipments we are seeing U.S. Customs stop and deny entry is also increasing due to IPR and copyright violations. U.S. Customs is there to protect those companies and their brands while protecting the U.S. population from fake and possibly dangerous products that are not properly approved for the United States. The last item I'd like to speak of is also something in which U.S. Customs has greatly increased their enforcement on. It is the de minimis exemption exemption for shipments valued under $800. Customs has and will be making substantial changes to the de minimis low value clearance process. As indicated on the slide, the timeline slide, we have seen an increase from 139 million de minimis shipments in 2015 to over 1.36 billion de minimis shipments in 2024. This increase is due to the explosion of e-commerce business and has forced the government to reevaluate the use of duty-free exemptions under the de minimis exclusion. On May 2nd, as we talked about on the timeline, all products of China and Hong Kong were excluded from entering the U.S. under the duty-free exemption. This makes all shipments that contain any products of China and Hong Kong dutiable, which may include a combination of some of the trade remedies we've already talked about today. CBP will also begin enforcements on August 12th of the $800 per day per person for de minimis shipments. This means a person will only be able to claim the de minimis duty-free treatment of up to $800 per day per product. Once that person exceeds $800 per day for that individual, all shipments will be then made dutiable. The U.S. administration has also included language in a recently passed bill giving U.S. Customs the right to issue civil penalties for misusing de minimis exemptions. This could happen due to many different reasons, and the penalties amounts will start at $5,000 for the first offense and then $10,000 for each additional offense. These are very substantial penalties. So UPS is taking every measure to be compliant to assure that we are properly using the de minimis exemptions. And lastly, that same bill also states the de minimis exemption is scheduled to be discontinued on July 1st, 2027 for all countries, not just Hong Kong and China as it is now, but de minimis will be canceled for all countries on July 1st, 2027. The language also states that these dates are subject to change, and if we learned anything from the last 5 months, anything's possible. So we'll have to wait and see how the de minimis enforcements roll out in the future. With that, I'll turn over to Catherine with an update from DC, and I definitely thank everyone for their time today.
Thank you, Mark. Good morning, everybody. My name is Catherine Mellor, and I'm in the UPS Public Affairs Office in DC. And I'm going to talk about what changes might still be ahead and help set the landscape as folks think about the future. Tell you a little bit about what we know, some of what we don't know. I know it's hard to believe after that presentation from Mark, but there's more. And I'll preface this by saying that it's a very changing environment. So we will update this information before we send it out. There are new announcements from the president just in the hour before this presentation. So the big news last week was updates to reciprocal trade agreements around the world. These are the country-by-country deals that are being negotiated under IEPA, as Mark mentioned, and new tariff rates are assigned to individual countries. They were originally outlined on April 2nd, 60 countries given a new rate, and they were designed, as Mark said, to address trade deficits and imbalances. The rates, for example, were 25% for South Korea, and those were to go into effect on July 9. The rates have been at 10%, and as of last week, the President Trump offered another short extension on the escalated rate out to August 1st while the negotiations progress. They are very complicated discussions, and we can assure you that trade ministers from other countries have been almost a constant presence here in DC. What we'd be looking for on an August 1st announcement is hopefully many deals that look like what we saw from the UK agreement, which came out on May 8th. That agreement avoided an escalated tariff rate. It set it at 10%. It provided some clarity on sector-specific tariffs. It committed to further negotiation, and in all of that, some medium-term predictability for the trade lane. To motivate these deals to be done, the president also sent letters to 28 countries last week, giving them a new tariff rate. That included new rates on large partners like the EU, 30%, Japan, Mexico, 30%. It was notable that there were some countries last week that we are negotiating with that were not given letters, and presumably that's because negotiations are proceeding well. India, for example, Taiwan. If we were to summarize this landscape for you all with some takeaways, the main points would be: one, the 10% baseline that we currently have on these countries is not going anywhere. Right now, the USMCA exempted goods is really the only zero tariff trade lane we have. There may be some exemptions or reductions in the future, but generally speaking, tariffs are going to start at 10% on a permanent basis. The higher rates that were articulated last week don't necessarily mean that those will be the rates that we end with on August 1st. The president has been transparent that he uses tariff rates to negotiate. So these aren't necessarily an indicator to plan for. And third, the whole approach to the reciprocal tariffs is designed around presidential discretion, the IEPA authority that Mark mentioned, and we'll talk about more of that in a minute. So even after these deals are done, there is the potential in this framework for the tariff rates to change. So look for August 1, some medium-term clarity, and hopefully some positive news for tariff rates maintaining a lower level around 10%. So to the next slide. Still ahead, a couple more things that we're tracking. The sector-specific tariffs that fall under that second priority of the administration, which is national security. The Section 232, as Mark discussed, steel, aluminum, autos. There are several more of these investigations underway. We are currently waiting for 9 announcements on new sectors under Section 232. 2 of those 9 categories were announced yesterday. They were polysilicon, an important component in chip and high-tech manufacturing, and drone subsystems and drone components, announced yesterday to add to the list of sectors being reviewed for national security and given a individual tariff. The other sectors are copper, timber and lumber, semiconductors, trucks, critical minerals, commercial aircrafts, and pharmaceuticals and pharma agreements. A couple of takeaways. If folks are interested in understanding what the scope of those goods may be under the category, if you're importing something in this category and want to see which tariff number it applies to, we encourage you to look at the Federal Register notice for more information. We caveat by saying that that does not indicate the full list once they're published, but there is an indicator of what kind of scope of goods the government is currently looking at. In the case of polysilicon and drones, the notice and comment period is open. If you're an importer of these goods, you're invited to provide a statement of potential impact for the government's consideration. Secondly, reminding folks that Section 232 tariffs are global. We'd love to see some countries carved out of these tariffs. There is some precedent for that, but we'd have to wait and see. Exclusions have not yet been a feature of this administration's tariff agenda. And lastly, in terms of the timing of the tariff rates, I would just be candid to say we don't know. We don't know when they will finally be announced and what the rates will be. We heard President Trump last week suggest that there was an announcement coming on pharmaceuticals that would include a 200% tariff implemented in 12 to 18 months. We took away from that statement a great indication that the administration is considering longer phase-in periods to allow for the objective of the 232, which is reshoring of manufacturing. But ultimately, that was just a statement from the president in the Oval Office. And as we mentioned before, these are often designed to motivate negotiations and not necessarily the final outcome. So turning quickly to other negotiations outstanding, US-China, of course. The good news here is that the US did reach a deal in London on the import of magnet and rare earths, which has allowed for the more reasonable tariff rate of 30%. The negotiations with China are not following a schedule of the rest of the reciprocal rates. And we don't expect the pause on the 30% to expire on August 19. It will much likely track with the negotiations between Washington and Beijing. Though there are many difficult issues for the US and China to tackle in trade, it is encouraging to hear the public statements from the US that a leader-level meeting between the two countries is being planned. So best case scenario is we're looking for a sustained period where the rate could be at 30%. And lastly, USMCA. This is our most comprehensive trade deal. This is the agreement that was negotiated and signed by the first Trump administration. There's statute and process involved in USMCA that's being observed by the three countries, including congressional engagement. But it is officially up for review in July 1, 2026. The IEEPA tariffs have complicated some of that dynamic, but it is notable that USMCA exemptions apply when other US FTA partners have not received FTA exemptions. I think the expectation is that USMCA deal is survivable, it's durable, and that there is a real commitment to the essential trading markets of Canada and Mexico for North American competitiveness. So to the next slide. Finally, looking into the future, and we mentioned before, there have been legal challenges to the president's use of the International Emergency Economic Powers Act for reciprocal trade tariffs and the removal of de minimis. There are several cases. The most impactful one you may have seen is in the Court of International Trade, which has already ruled that Trump's IEEPA tariffs were unlawful. That decision has been stayed. It is a roller coaster. So to just summarize it in terms of next actions, what we're expecting is that oral cases will be heard at the Court of Appeals of Federal Court on July 31st. A ruling would be expected within a week or two following that. If the Court of Appeals agrees with the CIT that Trump exceeded his authority under IEEPA, the tariffs would be struck down. Importers would be able to seek refunds for duties paid, and the administration would need to find an alternative legal ground to reimpose the tariffs. Or if the Court of Appeals finds that the US president acted within his authority under IEEPA, the tariffs remain fully in effect, it's status quo. In both cases, win or lose for the White House, we'd expect the losing plaintiff to appeal to the Supreme Court, and they will hear the case in the 2025-2026 session with a ruling likely not before mid-2026. The case against Trump's use of IEEPA is strong, but it is impossible. And I asked ahead of this opportunity to talk with you all for some handicapping of outcomes. It's impossible to predict how the courts will rule. And as I said before, should IEEPA get struck down, the administration has alternative laws it can use to put these tariffs back in place. So watch this space. Lastly, I wanted in my next slide to talk briefly about what we do in DC to engage in this policy environment where there is a lot of change and where we know our customers are experiencing the impact of these tariffs and some perhaps unintended consequences, certainly operational challenges. Firstly, we have cleared advisors here at UPS. So technical experts on UPS staff are participating in both the US Trade Representatives Industry Advisory Committee, where they're reviewing and commenting on the negotiating text for the reciprocal agreements, and also the Customs and Border Protection's Commercial Operations Advisory Group, where we provide feedback on the impact and implementation of customs changes, asking for things like appropriate time to prepare, making sure the guidance around changes is as clear as it can be, and offering input on ways to ensure the borders still move effectively. Secondly, beyond our cleared advisor status, we join trade associations and other companies in Washington to share ideas for making these policies better while still supporting the goals of the government. For example, with the National Association of Manufacturers, we're part of a policy proposal to create a speed pass for importers of critical inputs, those inputs that would be classified as must use, must source internationally, a critical good, that would have the opportunity to earn a rebate to offset tariff costs from the government for dollars that ultimately are spent to sustain US manufacturing. We've also had our own technical experts draft recommendations to simplify the process for low value shipments, providing alternative methods for de minimis. And we lead a group of companies talking to Congress about tariff exemptions for essential medical goods, particularly goods that are important to public health. I will say that not all of these ideas will advance to change, but it's important to ensure that the experience of importers and exporters are being heard by policymakers and that creative ideas are being included in this decision-making time, this time of change. So with that, that is all we have from DC looking into the future. And I'd now like to turn it to my colleague, Jessica Rosen, to talk about some strategic responses.
All right, thank you. So we're going to shift gears, as Catherine mentioned, in regards to strategic responses. And during the last webinar, we had provided some 10 steps of trade remedies. So we're going to shift that direction and point more on the trade landscape aspect and talk a little bit more about how we're going to be reacting versus how we're going to be more putting a plan forward. So basically, we're going to be shifting from the contingency and crisis mode to that functional plan that's going to be a bit more flexible and talk about the evolution of the reactive to proactive. So the section will be more about resilience and foresight and competitive advantage in the trade. So we're going to do a recap and a refresh in regards to those trade remedies that were presented to the prior webinar in April. So we'll get into it. Starting off, we're going to review the first piece of it, which was assessing the tariff impact. So based on the Q&A, we know there's still a lot of questions in regards to assessing the tariff impact. What we had talked about was making sure that you understood how they would affect your product costs, affect your bottom line, and working to collaborate with suppliers to understand the pricing shifts. So in some instances, that could mean taking a look at your terms and conditions or your supplier contracts. So that was the original step one for being reactive on the trade remedies. The next one is really verifying your product classifications, making sure that you have accurate classification codes. Do thorough research and make sure that you have documentation to substantiate that research. You'll need to consider the USMCA in regards to how your classifications are going to play into the USMCA and how that's going to work going forward. The next step is going to be really taking a look at duty drawback. So duty drawback is an opportunity for you to potentially receive refunds of up to $99 on duties of re-exported goods. Now, there has been some changes in eligibility over the years. We can certainly help to assess that qualification, or you can enlist an expert to take a look at the eligibility. But that was an additional step of step 3 was the duty drawback. And coupled with that is step 4, which is considering foreign trade zones. Also an opportunity potentially to defer, reduce, or eliminate duties. It's a compliant government program that allows you to bring goods in and manipulate and manufacture within a foreign trade zone. You can also leverage a bonded warehouse, which will allow you to bring goods in duty-free until the goods enter U.S. commerce. And then there's the transportation and export bonds for those goods that are going to be moving in transit through the United States, perhaps from Canada to Mexico or vice versa, as an example. Next is validating your product of origin and product valuation. So taking a close look in regards to your products, how they're being validated in regards to the countries of origin and the product valuation. That could also mean taking a look at your bills of material and your components that are going into your end product. We've got Chapter 98 as a duty-free provision. which will allow you to explore the opportunities for that duty-free status within your entries. And number 7 is addressing surety bond concerns. So we have a plethora of information in regards to the potential for surety bond concerns. In this moment of April, we're taking a look at how is this going to impact the value of the goods that I'm bringing in? Is it in excess of my bond? And do I need to work with my surety in order to increase my bond? One of the recommendations that we have as an organization is not to continuously go up and down with those bonds, but establish a threshold that is going to be, I would say, flexible enough to accommodate the trade tariffs that we're experiencing right now. Number 8 is going to be looking at ACH, so the automated way to pay your dues and taxes with customs. It makes sure that you have your finance side in order. Eliminates your broker from the responsibility of potentially doing that if your broker does allow that. And it allows you to have firsthand visibility in regards to your cash flow and what's coming and what's going. And number 9 is investigating cost controls through the consolidation and mode shifts. So if you're currently using air freight, can you use ocean? If you're using ocean, can you do an ocean rail or an ocean air? And taking a look at opportunities to control costs through being more creative on how you're moving your goods from point A to point B and throughout all steps within your supply chain. And that leads to optimizing your supply chain. Actually map it out, right? So you can take a whiteboard and actually take a look at what is coming from where. If you have a very large, complex, multinational organization, this could be a little bit more of a Herculean effort, but still recommended maybe you focus on the 80% versus the 20% of where your costs are and where there may be an opportunity for you to rearrange that potential supply chain. So that's a recap of April 10, and now we're going to move into a little bit more about the operationalizing the strategic trade responses. So when we were meeting in April, we were experiencing unicorns. Trade disruptions are no longer unicorns. They're constant, they're compounding. We're seeing this over and over again. So it is a recurring theme, and compliance is a focus. It's no longer an afterthought. Many of us on this call are compliance, and we have the ear now of C-level and executive levels of the organization. So how do you manage this? How do you make sure that the messaging is mastered so that way they understand where the focus needs to be from an organizational standpoint? And one of the things is looking at best practices in presenting supply chain agility. We're also hearing a lot about nearshoring or supply chain shift. So nearshoring doesn't necessarily mean that it always has to just be coming very into the United States, but also shifting your supply chain, dual sourcing, and dynamic routing. We spoke about dynamic routing a little bit on the other slide, but as you're exploring new opportunities to source goods and exploring the new modes of transportation that maybe you have not leveraged in the past, that's going to provide you the agility that you need in order to remain flexible during the current trade situation that we have today. When you also want to take a look at being flexible, you need to have the ability to do financial forecasting. So the ability to go into a system and scenario plan for tariffs. Doesn't necessarily need to be fancy. It could be an Excel spreadsheet, but having the opportunity to say best case, worst case scenario, or what if the tariffs do shift in one direction or another or to another country? Also, let's not lose sight of forced labor. I know that was brought up earlier, but it's important to reiterate that forced labor is not going away. It's going to be a continued theme between now and throughout this administration, especially when you take a look at the new country agreements that are coming out. This is certainly going to be an area that is going to be of continued focus for CBP. So in your financial forecasting model, what if something gets held? Do you have a backup? Do you have a backup supplier? Or how is that going to impact your goods and your inventory? If you're handling inventory just in time, is there an opportunity for you to build that buffer? Under real world trade compliance strategies, obviously no company names are mentioned here, but this is an option for you to just take a look at what types of areas have companies explored and implemented to better help their organization remain competitive and remain agile within today's economy. shifting sourcing and looking at FTA countries. And also now, as we're looking at these new agreements that are coming out, take that into consideration as you're looking for those models. And from a retail standpoint, there was an organization that used tariff engineering to lower their apparel duties and really digging into how their goods are being made, and also looking at the thread or the type of origin for their retail items, so that way they could bring those in with lower duties. And certainly making sure that they're doing this compliantly, right? There's a need to make sure you do proper vetting if you're going to be shifting. Automotive, leveraging bonded warehouses for duty deferral, bringing goods in until you need them into the United States, and holding on to the cash flow so you don't have to pay the dues and taxes immediately. You can wait until you absolutely need those goods. Making sure that you secure favorable classification codes with advanced rulings as necessary. And that is going to allow you to have at least security to know that you are stable and that you have the proper classification going forward. And it'll allow you to substantiate, again, that classification, something that we had previously mentioned in the slides. And then automated compliance with cloud-based systems. We continue to hear about AI. I don't think AI, in my opinion, is ready for prime time to fully replace everything, but we do need to lean into it. And if you have the opportunity to enhance and further automate some of your processes, manual intervention can lead to errors, and having that automation will allow you the opportunity to mitigate those errors going forward. So we can move on to the next slide and talk a little bit more about the advanced trade strategies, specifically in leveraging those FTAs. And when we talked about the supply chain mapping, you can also layer into this FTA mapping. And that could be anything from USMCA, or also we can consider the CPTPP, which incorporates other countries. You know, we are in the United States, or most of us are on this call. And if you're in another country, in another region, there are a number of different trade agreements that could support your complex supply chain and support how you're sourcing, to be able to leverage those FTAs into and out of other countries. So make sure you have your origin documentation stored properly. Make sure that you have the right validations, but that is absolutely something to take into consideration. But you want to make sure that your documentation is audit ready. When you consider customs brokers and 3PLs, share forecasts. That's going to allow your brokers to staff up or staff down and have that flexibility as appropriate, especially if part of your reaction to trade changes is to either front load or back load your inventory. Maybe you're holding back and you want to wait and see what happens, and that's going to lead to an influx of goods. It's important to share that, as well as your goals, with your broker. They should be your partner in working with you for risk mitigation. Develop those SOPs for accuracy and speed. If you have an opportunity to provide a classification database, or how they should be communicating to you with those instructions as these things are changing, or you're changing sourcing, ensuring that your broker and your 3PLs are a part of that conversation and understand your specific landscape shifts, that allows them to make sure that they have, again, that flexibility. I would say that no longer does one review a year suffice. Things are moving too quickly. It needs to be a living and breathing document, and you should be having these conversations with your trade partners more regularly. We talked about the classification and code audit, so let's move just one more brief point in regards to the trade data analytics. And this is where you can establish dashboards. I had mentioned before, it could be Excel or it could be a fully cloud-based system. There's also opportunity to take what you have today and create dashboards in either Power BI or other different types of tools to allow you to manage that information. You want to make sure you're doing entry validations. You want to check your licenses if you have licenses, and you want to make sure that your record keeping is tight. So especially when we are expecting more enforcement from CBP, we want to make sure that within that enforcement, that there is an opportunity to pull the records as you need them. And then finally, we'll touch a little bit more in regards to the strategic trade management onto the next slide. So we're going to talk in regards to optimizing and innovating beyond baseline compliance. That's a key takeaway here. Baseline is no longer good enough. You're going to need to think ahead and allow the ability to innovate and optimize in order to remain competitive within this environment. There's an investment in technology, training, and strategic partnerships. Investment does not always need to be monetary. It could be time, it could be personnel. But investing in technology, training, and strategic partnerships is going to ensure that you have that competitive advantage. We talk quite a bit about maintaining agility and doing so amid the global trade volatility that exists today. Monitoring your tariffs, monitoring the sanctions, and making sure that before you ship, you understand what not only the landed cost is going to be, but also what the rules are in regards to shipping those goods. Again, not simply just into the United States, but across different countries in the globe. This is not just a US situation, but there's also geopolitical shifts that happen all the time that potentially get muted during the current trade environment that we have in the United States, but trade constantly shifts. And finally, maintaining flexible sourcing and routing strategies is going to needs to be maintained and is important. So we'll move into a resources slide to allow some time for Q&A. And this resources slide will be available. There was some questions in the chat. Yes, we will be able to provide this as follow-up. So that will be sent, and then you will have access to these links. If you are interested in global trade advisory services, duty drawback or foreign trade zones, you have the links here and the email addresses to send an inquiry. Also, if you have general questions and FAQs, there's also a link available. We have market updates that happen on a regular basis. Maybe you want to have a more regular inbox email that provides you logistics, news, and market updates. That is a link there, as well as customs available resources. And always going to the source is very important. So there's a tariff resource link for the CSMS, or the Cargo Systems Messaging Service, that Mark spoke of earlier, and it is referenced throughout the PowerPoint. There's also an ACH setup process to pay your duties and taxes directly, a White House fact sheet, which is a document released by the White House that provides information on specific topics or policy initiatives. They're intended to inform the public and other stakeholders about the administration's stance, actions, and goals on this particular issue. And then under the CBP FAQs, there's a specific page for trade remedies. You can find a significant amount of information there. With this, I will turn it back over to Anne to lead us into any Q&A.
Awesome. Thank you, Jessica. I'd just like to take a couple minutes and thank our speakers and panelists for sharing really important insights from their respective areas of expertise. I think it was super helpful, especially at this time of everything going on. So thank you all again. And I want to thank everyone, excuse me, for being so active and submitting questions in the Q&A function. As we continue to answer those, we did have a few questions that were submitted prior to the webinar through the registration. So we are going to answer a few of those. Mark, the first one is for you. And it's how are tariffs calculated on metals that have some percentage of aluminum or steel?
Thanks, Ann. Yeah, this is something I kind of covered through the presentation, and it has become very difficult. So when you talk about aluminum, steel, if it's an aluminum product that falls within Chapter 73 or 76, the complete value is actually subject to the 232 tariffs. Right now, it's at 50% for most countries. If you have a derivative, you need to break out the value content of the aluminum product and the non-aluminum, the aluminum content and the non-aluminum content. Then you only be charged the Section 232 on that lower aluminum value content. So the commercial invoice is very important, and make sure you break that out, because that will keep you from paying or overpaying duties and taxes for the Section 232 aluminum steel content.
Okay, thank you, Mark.
Got
This
it.
one is directed to Jessica, and it's our products are being misclassified as auto parts, and we are being charged a 25% tariff.
Okay, so first you're going to want to make sure that you're conducting a classification review and making sure that between your internal expertise and potentially a broker or trade consultant, you want to make sure that your classification is correct. And you want to align with your broker to make sure that they have a product database and SOP for instructions. If the classification is not correct, you can file a post-summary correction or protest depending on the entry status and timing. You can do that yourself, or you can also work with your broker to do that and support that. If you believe the classification was enforced incorrectly by customs, I would say to gather some technical specifications and to support your case, and you can certainly go back to customs and leverage your broker in that way. If you paid the 25% incorrectly through the PSC process, depending on liquidation status, there also could be the eligibility of a refund there.
Okay, thank you, Jessica. The next one, Mark, is for you, and I think it probably is questioned by a lot of people. Are the social media tweets official communication on upcoming changes?
Yeah, nowadays we have to live on social media. A lot of communications coming from that. We do see a lot from True Social from the president, and those are official communications which start the process of how certain tariffs will be implemented. So we see something on True Social from the president. That usually means an executive order is coming, then a federal register is coming, and then that final CSMS, which we've talked a lot about, that final CSMS will come out with the exact details, timeline, and how we're going to implement that. So, to say it's official, but it's not the official process that we'll have to go through. So we do continue and we do watch those daily, hourly, minute by the minute, just to see what's happening because this is a volatile time and a lot's going on every day.
Yes. Okay, thank you. Okay, Jessica, does UPS provide publications or newsletters to inform customers of change?
So yes, we have a number of publications that you can sign up to receive. There's wonderful resources from the links on the slides. And also I'll put a link in the chat here to be referenced that allows you to sign up for news and market updates. You can also reach out to your UPS account representative and request access to a compliance weekly broadcast.
Okay, perfect. Mark, if a shipment valued under 800 is valued under 800 that contains multiple products with multiple country of origins, and one of those products are made in China, can I still clear as duty-free under the de minimis exemption?
Yeah, de minimis. That's huge right now. In this scenario, since you do have one product that is made in China or Hong Kong, it will then force the complete shipment to be dutiable, even though that one product may be valued at $10. So anytime you have a shipment that has China, Hong Kong, or Macau products, we cannot clear it as a de minimis, and we'll have to pay the proper duties, which then could lead you into the IEEPA tariffs, the Section 232 tariffs. So that country of origin is important, and especially if you do have something in there with China and Hong Kong, you will pay the duties.
Okay. We have time for one or two more. Jessica, they're asking, why do brokers assess other fees along with the duties and taxes that are charged by customs?
So it depends on the broker, right? So I can speak to how we do things. And as a broker, we charge a brokerage entry fee as a service provider, and that's for the service of actually performing the act of the customs clearance. Additionally, you may see one or more various duty fees, which are government charges, the charges that we've been talking about here today. I would recommend that if you have a question on an invoice, if it's a UPS invoice, reach out to your account executive, or if you don't know who that is, you can also request support from the billing team. There should be a phone number or an email address on your invoice.
So, okay, thank you. Well, that is going to conclude today's webinar. If you have any further questions or if we didn't get to any in the Q&A, please utilize the survey that will pop up after the webinar. It'll allow you the opportunity to ask any questions or even request that UPS or reach out to you. So once again, we appreciate your trust in UPS and we hope you have a wonderful rest of your day. Thank you.